Yeah. We don't have time for all that countdown business. Get in here. Get in here right now. It's your legal bestie, Attorney Symone, and we have an urgent hearing. Listen, people have been blowing up my phone, sending me all these messages talking about, is it true? Is it true? Did the feds drop some charges against Diddy? No, it is not true. No, honey, but thank you for coming to your legal bestie, Attorney Symone, and I'm going to break down exactly why it is not true, but what did happen instead. Now, I'm Attorney Symone, your legal bestie. If you ever want to consult with me, you can go to SymoneRedwine.com. You can book up at the top there, book Symone for consultation. And you can also buy my ebook, which is Background Checks 101, the beginner's guide to figuring out who the heck you're dealing with, right? Because we want to make sure we ain't dealing with no scammers or anything like that. Now, back to the business at hand. So it's not, in fact, that any charges were dropped. And this is all over, right? Baller alert, feds drop kidnapping, arson, and trafficking charges in case this trial focus narrows. And then we've got Hollywood Unlocked, Diddy trial, prosecutors drop kidnapping, arson, certain sex trafficking charges. Okay, and people are up in arms, baby. Why would you get rid of arson? They're like, my question is, why would they do this right before a verdict? Let me tell you something. First off, thank you for asking, because a lot of people did in the comments. And I'm going to say this. It's not that people are out here lying. It's just a lot of them just don't know no better, honey. They don't know no better. They're not lawyers. They may or may not have been in the courtroom each day. But that's why you come to me, right? Because I won't always be first, but I will be accurate. I can't always be first, y'all, because I do have a real job. Like, I have actual clients. I got to tend to them first. So let's break down what really did happen. So what did happen is last night, let's move this from the stage. Last night, the feds filed a letter. They filed a letter with the court. And here's an excerpt, the relevant part of the letter. In that letter, it says, the government understands the court's desire for streamlined instructions. It says, with that in mind, the government has suggested ways to streamline those instructions. Specifically, the government has removed instructions from charges relating to attempted kidnapping under both California and New York law. So those were the alleged kidnappings of Capricorn Clark. New York was when they put her in that warehouse room for 5 consecutive days, making her take that lie detector. And then it was also with Capricorn Clark in California when allegedly Diddy came there at Pow Pow Point and made her ride with him to go and try and unalive Kid Cudi. Those were those two. Secondly, they said that they are going to remove the attempted arson under California law pertaining to Kid Cudi's car. And finally, aiding and abetting as trafficking. They're going to get rid of those. In quote, it says, the government is no longer planning to proceed on these theories of liability, so instructions are no longer necessary. Here's the thing. That is not any way, shape, or form dropping charges. First of all, you can't drop charges that were never initially filed. He was never charged with kidnapping, arson, or aiding and abetting. What he was charged with was RICO. These are underlying RICO offenses. If you've seen my Instagram post, I'll show it later in this, but if you've seen my Instagram post, you're familiar that what did happen was I did a little RICO breakdown. That's actually, it looks something like this. I'm just going to play a snippet of it for you real quick.
People are asking, where's the RICO? I'm your legal bestie, Attorney Symone. I break down celebrity cases on social media. Here's what has to be shown. Number 1, that there's an enterprise. Number 2, that there's an agreement within the enterprise to operate for a common goal, and that there's a pattern of racketeering activity. First, we know there's an enterprise. It's literally called Sean Combs Enterprises. But
you get the gist. So the point is, these were never charges. You can't drop charges that weren't brought.
And the thing is, it's legally incorrect to say that the government has dropped charges. Specifically, what the government has said is, quote, the government is no longer planning to proceed on these theories of liability. The theory just refers to the specific aspects of how it's done. It doesn't mean it wasn't actually done. So the truth is, all the charges are still there. They're just saying that in their closing arguments, they're going to focus on specific ways in which crimes were accomplished. That makes sense. Because at the end of the day, the prosecution doesn't know exactly what evidence is going to be presented until it's presented.
Here's what did happen. So what happens is, first of all, let's be clear. They're saying they're dropping attempted kidnapping under both of those states' laws and attempted arson. Let's look at the indictment real quick. I'm going to make this a quick video because I'm going back to court today, so I don't have time to be playing with y'all. I got to get you straight and narrow. And if you got anybody out there that keeps repeating this inaccurate story, you got to tell them, oh, you should meet my legal bestie. Say it real nice, not nice, nasty. You got to say it nice because they just don't know better, okay? You got to say, you got to meet my legal bestie on YouTube, okay? Because here's what did happen. Now, first, I'm going to show you an excerpt. This is from the indictment. So the top part is the letter I just read. The bottom part is the indictment. Listen, what does the indictment say? That there are multiple acts involving kidnapping, right? This is YouTube kidnapping, chargeable under the following states. And here are the different provisions that were charged that he's being pursued for related to kidnapping. And that is attempt, it is aiding and abetting the kidnapping, conspiracy, as well as kidnapping itself, as in the completed act of kidnapping. So what you'll see here is what I did is I took my little marker and read, and I cut out what the government said. They're no longer attempting. So under kidnapping, it's merely they're not going after attempted kidnapping. They are still going after kidnapping. Hello, order in the courthouse, okay? They're still going after that component. And here's why. Well, it makes sense. We don't want to confuse the jury. These instructions are complicated enough. No need to confuse the jury, because at the end of the day, you either kidnapped him or you didn't. You kidnapped her or you didn't, right? So you don't want the jury to be like, well, competing between the two. It either happened or it didn't happen. So therefore, it makes sense. Take out the attempt. Secondly, same thing with arson, right? With arson, here's how that's going to look. With arson, they did the same thing. You either burnt up the boy's car or you didn't. In this instance, we saw photos of the completion. And at the end of the day, hey, in my opinion, the arson charges were really weak. I think it's one of the weaker charges. So I don't think you were going to get 12 people to agree on arson anyway. But to be clear, they only eliminated attempted arson. Now, I'm going to show you what's important is looking at this right here is the indictment section. But look, I'm going to also show you what the jury form looks like. Here on the screen is kidnapping, and then we're going to do it again for arson. This is kidnapping from the indictment. This is the jury verdict form. This is the only change. So on A, if they're going to ask the jury, if you found the defendant guilty of count 1, which is racketeering specifically, then please indicate what patterns of racketeering activity the defendant agreed would be committed. That involved kidnapping, no longer attempt, right? But still aiding and abetting kidnapping, or conspiracy to commit kidnapping in violation of California law. And then it says the exact same thing regarding New York law. So in other words, for those who have asked, why would they do this before a verdict? Or more importantly, why would they get rid of arson's the next one, arson? They didn't get rid of the whole charge of arson or kidnapping. They only got rid of attempt. All right. So then secondly, I just want to make sure, because I come with receipts, y'all. This was what they said about the kidnapping. Here's the section on arson. With the arson, it says, quote, from the indictment, there are multiple acts of arson chargeable under the following provisions: arson, attempt arson, aiding and abetting arson, and conspiracy. In other words, he can still be found guilty of arson itself, just not the attempt. He can still be found guilty of aiding and abetting arson or conspiracy. Any of those. It doesn't have to be all three. Those are still on the table. Those are still on the table. So how are you going to drop a charge? Number one, that was never charged. And number two, they're only saying we're not going after the attempt. And if you look at the verdict sheet here, look, that's the only difference. If you have found the defendant guilty of count 1, indicate whether the pattern of racketeering activity that the defendant agreed would be committed involved arson, no longer attempt, but arson, including aiding and abetting, or conspiracy to commit arson in violation of California law. Any further questions on that one? Okay, we're going to proceed. So this is actually what the jury verdict form, if the judge accepts it, this is what it's going to look like with these revisions. I put this up here because I just want to show you how minor this impact is. And more importantly, how incorrect certain sources are that are saying Charges were dropped. Charges are dropped. And I want you to please share this with Facebook, share this on Twitter, and wherever you see someone perpetuating this incorrect information, this is where you just drop in their comments, say, oh, you need to meet my legal bestie. You need to meet my legal bestie. Now, don't put that on any other content creators' pages because they'll probably block you. Understandably, don't piss them off. But I'm just saying, just tell them you need to meet my legal bestie. And last but not least, I can't forget to address the elephant in the room, which is this excellent question that it appears Melly Mel has asked, which is, why would they do this right before a verdict? This is why they didn't call witnesses on their side. She says they knew this ish was not going to stick. He may get a little time, but definitely not life. I agree, he's not going to get life. But I will say this, here's why they likely did this right before the verdict, is because this verdict sheet and these instructions are going to be real complicated. This is an all-American jury. It is probably one of the most, if not the most, diverse jury that I've ever seen. And not just by race, by socioeconomics, by the types of jobs, ages, etc. And what you don't want to do is present multiple charges that would confuse a jury so much that they can't agree. And one of the reasons they may not be able to agree is if they don't know what's being asked in the first place. So it makes perfect sense in a situation like this to remove the attempt charges for the arson and the kidnapping because he either did it or he didn't. The only time you want both an attempt and the actual completion right would be if there's a situation where there's two separate people. Let's say it's someone is accused of pow-powing someone, and maybe there were two friends that were pow-powed at. One person got hit, one person didn't. That would make sense for the charge to be assault and attempted assault, because the person you didn't actually hit with the bullet would be attempt. Here, where the woman took the stand and she said, this is what happened to me. Ain't no attempt. If you believe Capricorn Clark was kidnapped, it was a completed act of kidnapping and or conspiracy or aiding and abetting conspiracy, but it's not, it's one or the other. No one is going to decide that you were both attempted kidnapped and kidnapped. So that makes sense here. The other thing that makes sense is, again, you want to streamline the instructions so that there's no confusion. And last but not least, guys, thank you so much for disrupting my day, asking me about this, because I love the opportunity to clarify the truth. And as you come on here, don't forget, you want to shake that astroglide. That's what we do on this channel, okay? I don't have a bullhorn. I got a gavel and some astroglide, because apparently you never know when you need both a gavel and some astroglide. I've got both. Shake that astroglide as you come on out of here. Drop your questions below. I'm your legal bestie attorney, Symone. Drop your questions. Share this. Oh, subscribe. Yes. I'm new to the show. Subscribe and tell everybody. Let me know other questions you have. I'm going straight to the courthouse. I'm already there at the time that this is uploaded, so I'm sorry it's not live. I got stuff to do, and I got more things to clarify because this is a bunch of inaccuracies. But thanks you guys for watching. Check you later. Bye. Your legal bestie, attorney Symone.